Hi, welcome back. My name's Amar. I'm here with Jennifer McGibbons. Today we're going to talk about setting up an irrevocable trust, or maybe you have set up an irrevocable trust for your children, and then a couple of years later you're like, rats, that wasn't the right thing to do. Um, Jennifer, I'm sure you've experienced this with your clients from time to time.
Yeah, so it's either clients of mine who have set up themselves, so they were the grantors, the creators of an irrevocable trust, or sometimes, honestly, I have clients who are the beneficiaries of an irrevocable trust. And just by the nature of the term of the trust, it's difficult to make changes to those types of trusts because they're typically non amendable and not revocable.
Yeah.
So how do we go about, or examples of that would be like a life insurance trust. We'll see a lot of those that are sometimes held to hold life insurance proceeds outside of your estate when you pass away. Also, gifting. When a client wants to make a gift for the benefit of beneficiaries, but they want to hold it in a trust structure, that would be an irrevocable trust as well. We'll sometimes see them for charitable trusts as well. You want to make an irrevocable gift to a charitable remainder trust or a charitable lead trust. Those types of trusts will be irrevocable as well. So they're a big part of estate planning for sure. They're just a little bit more difficult to make changes to those once you get them set up.
And
There
we
are,
have,
oh, go ahead.
sorry. I guess what is the main benefit of these irrevocable trusts is those assets are outside of your estate, right? I think
Correct.
if somebody were to sue you or anything else like that, those assets are outside of that individual's estate.
Yeah, so you're providing some creditor protection. It's really also for estate planning purposes. So you're shifting assets outside of your estate so that they're not subject to estate tax when you pass away.
Yeah.
So there's both third party protection, so creditors, divorce, there's also estate planning benefits to creating these irrevocable trusts.
Yeah. And now let's look at the scenario that you set one up and you're a beneficiary of one and you're like, well, this doesn't really work for what my parents intended or what I wanted or whatnot. Can you change these?
Yep. So we always there's typically three different phases for this. One is you always start with the trust document. So you'll look at the trust first and see what's the nature of the changes you want to make, and maybe there are already provisions built into the trust that allow certain changes. These days, as I'm creating irrevocable trust, I try and build a lot of flexibility, a lot more flexibility into these documents than we did previously. So if it's an older trust, most likely we're not going to see the ability to make a lot of changes inside the trust, but that's where we'll always start. Can you change the trustee? That's pretty common in these irrevocable trusts. Is there a trust protector in it, giving some third party the ability to make certain changes? Can you make certain administrative changes that are allowed under the terms of the trust? We brought up charitable trusts. Sometimes in those charitable remainder trusts, you can change the charity, and that's allowed inside the trust. So we always start with the trust document. Can we make any changes, or can we make the changes the client desires inside the trust just based on the current terms? If we can't do that, then typically there's two other options. One is under the California Probate Code. We do have the ability to make modifications. If the people who created the trust are still alive, then you just need their consent as well as all the beneficiaries' consent. If the person who created the trust is now deceased, you have the option to go to court. Here in California, we always try pretty hard to avoid having to go to court. So it's always much better if both parties or the person who created the trust is still alive. And that's just a modification process. You look at it under the probate code, pretty straightforward. But again, everyone needs to consent. So, for example, you have a beneficiary who's supposed to receive assets at 45 and you want to change it to 25, that beneficiary is likely going to say, yeah, of course, I'm going to consent to that. But if the beneficiary is supposed to get it at 21 and you want to bump it out to 40, that's going to be harder to get that beneficiary to consent to that. So sometimes you do have to go to court in any event to get the court to or the judge to approve it. And then the third option is decanting. And so here in California, we do have a decanting statute that allows, just like, the concept of wine being decanted from one bottle to another. It's the same concept with trusts. We're moving trust assets from one trust vehicle and you're moving it into a new one. There are quite a few limitations and restrictions here in California as far as the nature of those changes you can make. Other states are very broad on those. So if you have the ability to move to a different jurisdiction, that's definitely an option. But California does allow the ability to change the trust terms through decanting. You definitely want to meet with an attorney and make sure that they can walk you through what the parameters, what the restrictions are. But that you don't need the beneficiaries to consent. So that can be a really helpful vehicle to use when you don't need to involve the beneficiaries. It's just the trustee who's the one who's making that decision to decant.
Yeah, absolutely. So I think that what would you say are like the first couple steps in the process is to review the trust documents.
Yep.
Meet with an attorney.
Yeah, definitely review the trust, figure out the nature of the changes you want made, meet with an advisor. Sometimes that can be someone like yourself, Amar, who's meeting with clients on a frequent basis and taking a look at their estate planning documents. It could be an estate planning attorney, whoever their kind of main advisor is. Eventually, you're going to have to get to an attorney, most likely, because we're the ones who are going to be drafting the documents or giving recommendations as far as the best course to go. Also, sometimes trusts just aren't created here in California. So they're outside of California. Am I the right attorney to advise on that? Probably not, because I'm licensed to practice here in California. So it's really just meeting with an advisor, figuring out the terms of the trust, what changes do you want made, and what are the different options available to make those changes.
Sounds good. So if you're in California and you have questions about an irrevocable trust, you should please reach out to Jennifer or myself, and we'll be more than happy to help. Thank you for watching.
Thank
Bye,
you.
Jennifer. Yep.
Bye.